Okay, I'm Marv Tuttle. I'm covering for Robert Medell tonight. He had to go on vacation or something. I don't know exactly what he's up to. So I'm acting in his stead. I'm working from an incredibly small set of notes that I made, because if I were to make a complete set of notes on our guest speaker tonight, I'm the only person that you would hear tonight, because our guest speaker is quite distinguished and a successful attorney. But there's a couple things that he has done that I thought would be of importance to our group. I've been told he was a former secretary of the Californians for Disability Rights. And that's a huge thing for us. Also the founder of the Center for Disability Access. And tonight he's going to present to us, the title of his presentation is Looking Back and Looking Forward, Disability Rights in America. So with that, I'd like to pass off and introduce our distinguished guest and attorney, Mr. Mark Potter.
Thanks a lot, Marv. Yeah, thank you, and thanks for having me. I really appreciate it. I was really happy that Robert gave me a call and had me come up here to meet with you guys. And we've put together a presentation here, and it starts with a video. Then we can I can get completely over my food coma before I go over the rest of the presentation. We have two videos here to sync. You ready? I think yours goes just a couple of seconds. You should go a couple of seconds before me. You ready?
So I wait till after that count down.
I see.
So wait till that goes.
That's right. So you tell me when to go.
All right. I think we're ready.
It was also not a part of the original civil rights movement that swept this country. It started with the idea that civil rights should include more than poverty in general. That civil rights and protection or discrimination should be extended to persons with disabilities. But the idea had to be sold. Awareness had to be taught. Persons with disabilities had to communicate and to advocate and to instruct. It required meetings and lobbying and a real grassroots effort. Ultimately, it required food.
Oh, yeah.
Deserving of basic civil rights protections. This class status concept has been critical in the development of the movement. The 504 was limited to the recipient of federal funds. A broader law was needed. A national campaign was initiated. People with disabilities were asked to document daily instances of inaccessibility and discrimination. And it worked. By overwhelming bipartisan vote in the Senate of 91 to 6, Congress passed the Americans with Disabilities Act. And on July 26, 1990, President George H.W. Bush signed the bill into law with great ceremony. What a historic day that was.
On the day Bush signed the ADA, we convinced him that we should make it a great big celebration since there's so many people directly affected by the passage of the ADA.
It was a glorious day, July 26, 1990. Clear blue sky, the sun was out for 3,000 or 4,000 people, many with disabilities and their families on the south lawn of the White House. And the president was on a platform with leaders of the disability community to sign the bill into law. It was so hot. That's what I remember. It was so hot. But you know, people were sweating and dripping, and you know what? It didn't matter.
How you describe the signing ceremony? We had people everywhere. Grenades, white canes, wheelchairs, walkers, and seeing-eye dogs. I mean, any device that helps people get around was represented that day. We covered the White House lawn for sure.
The most people ever gathered on the White House lawn for a signing was July 26, 1990. Never been that many people there for a signing of a bill. Biggest group ever in the history of this country.
I had the pleasure and the real privilege to ride to the ABA signing ceremony with John McCain. So we drove right into the White House, and then we walked outside and became part of the masses. The House lawn was packed with people. All of them there had worked and worked and worked to see the law passed. So it was a shining day and a shining moment. And I mean, history and the weather just cooperated in a way you don't see very often.
I now lift my pen to sign this American.
And then the president ended his brief remarks with a clarion call: let the shameful wall
of exclusion
finally come tumbling down.
finally come tumbling down.
Less than a tremor through the entire crowd.
Best moment was President Bush was there. He was signing the ADA. Evan Kemp was on one side. Sandy Perino was on the other side. And there was a priest, Reverend Wilkie. And he had no arms. So the president signs the legislation, and then he hands the pen. He hands the pen to Evan, hands the pen to Sandy, and then President Bush hands the pen to Reverend Wilkie with no arms. So he picks up his foot and grabs it with his toes. Perfect moment right there. Let's talk about a Kodak moment, because that was really what it was all about.
There was a lot of pent-up emotion and anticipation in that crowd, and when the president finally put his signature on the bill, a great roar of approval went up. Extraordinarily special. And then the rest of the day was given over to celebration. A lot of folks who had put in years, decades, trying to reach the point that they've achieved that day, let their hair down and had a lot of fun.
Just this feeling of we did it. I mean, here we were having been told for so long how powerless we were, and here we were with the President of the United States signing this document that was our emancipation proclamation, essentially. It was just a fantastic feeling.
It was one of the most electric moments in time. It was like we were transported to another place. We were 20 feet off the ground. 3,000 people were 20 feet off the ground. It was like a tremendous party. A very controlled, love, respect, joy, accomplishment, satisfaction. Our time had come. We finally were recognized as citizens of the world.
I just thought of how much my brother had been discriminated against all his life because of his disability. When you see something like this and you see the president signing, that goes through your head. You think about this. You think, well, maybe this isn't in time to help my brother. But you think about how many other people will have to go through that, because of this. I just thought, gee, this is just something that I think is going to unleash a lot of people with disabilities in this country to do things that they never thought they could do before. And will change the atmosphere, will change how people think about things. And very emotional. For me, it's just a very emotional moment. I had the sense that the moment was one that I would never forget. That there was a ceremony, and the ceremony was very important. But the moment was much more than that. The moment was a recognition
of the rights and abilities of people with disabilities, the recognition of respect for people with disabilities, the recognition of and of discrimination against people with disabilities, and that spirit, the feeling so proud was that in American Sign Language, this is trying to that sign is called ta. That's how you make a sound when you say it, ta. And that was the ta day. That was the day that you guys saw us as your peers and not as someone who needed your help.
But what does it mean to be accessible or ADA compliant? The Department of Justice has adopted standards for accessibility, a sort of code book that is filled with diagrams and technical requirements that set a standard for access. The DOJ published this in 1991, and then they revised it again in 2010. They continue to work on new codes for accessibility. Consider what President Obama had to say about the publication of the new 2010 standards, which happened to coincide with the 20-year anniversary of the ADA.
Senior officials in the White House, and even the President himself, they understood this injustice from the depths of their own experience. They also understood that by allowing this injustice to stand, we were depriving our nation and our economy of the full talents and contributions of tens of millions of Americans with disabilities. That is how the ADA came to be. And to his enduring credit, President George H.W. Bush signed it into law on this lawn on this day 20 years ago. That's how you changed America. Equal access to the classroom, the workplace, and the transportation required to get there. Equal opportunity to live full and independent lives the way we choose. Not dependence, but independence. That's what the ADA was all about. While it was a historic milestone in the journey to equality, it wasn't the end. There was and is more to do. And that's why today I'm announcing one of the most important updates to the ADA since its original enactment in 1991. Today, the Department of Justice is publishing two new rules protecting disability-based discrimination, or prohibiting disability-based discrimination by more than 80,000 state and local government entities and 7 million private businesses. And beginning 18 months from now, all new buildings must be constructed in a way that's compliant with the new 2010 standards for the design of doors and windows and elevators and bathrooms. Buildings like stores and restaurants and schools and stadiums and hospitals and hotels and theaters. My predecessor's administration proposed these rules 6 years ago. And in those 6 years, they've been improved upon with more than 4,000 comments from the public. We've heard from all sides. That's allowed us to do this in a way that makes sense economically and allows appropriate flexibility while ensuring Americans with disabilities full participation in our society. And for the very first time, these rules will cover recreational facilities like amusement parks and marinas and gyms and golf facilities and swimming pools and municipal facilities like courtrooms and prisons. From now on, businesses must follow practices that allow individuals with disabilities an equal chance to purchase tickets for accessible seating at sporting events and concerts. And our work goes on. Even as we speak, Attorney General Eric Holder is preparing new rules to ensure accessibility of websites. Yes, we can.
Mark Potter, the head of the Potter Handy Law Firm, a founded the Center for Disability Access, a division of the Potter-Handy firm. The center focuses exclusively on disability rights under a variety of laws, including fair housing and the ADA. The center has been actively and widely representing persons with disabilities for the last 16 years. Mr. Potter has served as a board member for the Southern California Rehabilitation Services and as a secretary for Chapter Number 1 of the Californians for Disability Rights Organization, the oldest disability rights group in California. Mr. Potter has been practicing law for 20 years. He has been admitted to every United States federal court in the state of California, as well as the United States Supreme Court. He has successfully litigated thousands of disability rights cases and was featured on CNN discussing current trends in disability civil rights. He has given seminars and presentations to groups throughout the state of California. He has been invited to lecture at numerous venues, and he has spent a significant part of his practice in pro bono work, teaching and empowering persons with disabilities regarding their rights. The center has handled some of the most important cases that exist on the ADA. For example, CDA had a client complain about the California Speedway. He complained that when spectators stood up, which is quite common at these events, he could not see the action. Every time something notable happened, whether it was an accident or a photo finish, all the spectators stood up and blocked his view. The Speedway refused to modify their seating. The Speedway argued that the ADA did not require line of sight over standing spectators. CDA took the case. CDA obtained the blueprints and hired an expert to develop the argument regarding sight lines. And although it took 7 years in total, CDA convinced a panel of judges that the ADA required line of sight over standing spectators. They created law, and it now protects millions. Another client complained about AMC, the second largest movie theater chain in the country. He complained that while AMC had accessible seating areas and the required companion seats next to them, AMC refused to make non-wheelchair companions move from those seats when a wheelchair user needed them. AMC argued that because their auditorium was physically compliant, they did not need to do anything further. The center took this case also to the Ninth Circuit and won, creating an express obligation not only by movie theaters, but by all businesses to ensure that not only do they have the accessible features, but they must maintain them in such a way that wheelchair users can actually use and enjoy them. That same client had another problem. He complained about the city of Lomita in the county of Los Angeles. Lomita has a lot of public on-the-street parking stalls, but none of these public parking stalls are reserved for persons with disabilities or are otherwise accessible. CDA took the case. The city of Lomita refuses to this day to install accessible parking spaces. Lomita argues that it does not have an obligation under the ADA. CDA convinced a federal judge that the city did have that obligation and must provide accessible on-street parking. The city of Lomita has now appealed that decision. On January 29, 2013, the Department of Justice joined CDA in the appeal to the Ninth Circuit. Another client complained about the lack of accessible parking at a real estate office. The property owner argued that he did not have to provide accessible parking because the lease agreement made the business responsible. CDA took the case. The case went to the Ninth Circuit. CDA won that case, and the law of the land is now that neither landlords nor property owners can delegate away their responsibility to comply with the ADA. This ruling protects and strengthens the rights of millions of Americans. That decision is cited to on a regular basis. Another client complained that Del Taco, a popular fast food franchise, discriminated against him by failing to provide accessible restroom facilities. CDA took the case. Although the lack of restroom facilities was discriminatory and frustrating for the client, Del Taco refused to pay the civil penalty set by California law. Del Taco argued that a business only needs to pay the civil penalty if they acted intentionally. In other words, if they are just negligent for 20 years, no harm, no foul. As unfair as it sounds, Del Taco actually had a good legal argument because a California appellate court had agreed with their position in a different case. This was a blow to disability rights throughout California. CDA took that case to the Ninth Circuit and convinced them to ask the California Supreme Court to decide this important issue. Mark Potter and his team presented their case to the California Supreme Court and obtained a unanimous decision finding that even negligent violation of the law is worthy of the civil penalty and ought to be penalized. This resulted in the Clay Award. Clay stands for the California Lawyer Attorney of the Year. This highly prestigious award was justified because civil rights attorneys throughout the state of California understood that these civil penalties are the driving force that motivates businesses to act seriously and comply with the law. A law that has no teeth is ignored. If you believe that you have encountered unlawful barriers or inaccessible facilities or discriminatory policies or otherwise had your rights diminished, please do not hesitate to discuss the matter with one of the attorneys at Potter Handy. We will consult with you for free. If your case has merit, no matter how small you think it might be, we will take it. If we take your case, we will represent you for free. While these cases are not typically what attorneys might call big cases, the issues at stake are tremendous and for a distinct group of persons, those with disabilities. These are basic civil rights, and they deserve being championed. That is our mission. The California Legislature and the California Supreme Court agree. California law provides that if your rights to proper access have been violated in some fashion, you are entitled to obtain a penalty against the law-breaking business. This penalty ranges from a low of $1,000 to a high of $4,000 in the vast majority of cases. The California Supreme Court has held that this amount is to uphold the majesty of the law. It is a penalty that should be assessed against businesses that fail to comply with these important laws. A law that is not enforced is just a piece of paper. Senator Tom Harkin, one of the moving forces behind the ADA, famously noted that the ADA is the Emancipation Proclamation for the disabled. He also noted that no agency or organization has the resources or the mission to enforce it. Enforcement has been left by design to individual court action. You are the enforcement mechanism. Do not hesitate to call foul when you see the law being broken. Your efforts not only benefit you personally, but all persons with disabilities that come after you. It is a noble cause.
So that gives you just perspective on the civil rights movement, where it started, how we got to this place, and we can talk about the law as it is today. Is it kind of warm in here to you guys? I think you'll be able to hear me over there, Commissioner, don't you think? Yeah, I think no, it's not a. Actually, we don't need these speakers on anymore. Hey, Marv. The path is clear now. So the ADAG that President Obama was talking about, the 2010 ADAG came out, and before that there was the ADAG that was passed before it. It's the federal building code as it relates to disability access. It spells out just about everything you can think of related to disability access. You know, people often, it seems a mystery to them, how many parking spots are they supposed to have? Well, it's all spelled out in great detail. Like, here's the chart, and this is straight out of this is a page right out of the ADAG, and it spells, you know, you just find out how many parking spots they have. That's how many, and then you can figure out how many accessible spots they have to have, and then in other spots it spells out the dimensions, that it has to be flat. What does flat mean? With less than 2% slope, blah, blah, blah. It's all covered in specific detail. So you can tell if it's in compliance by simply having you know, a calculator and a measuring tape. And there is. You know, I don't know off the top of my head. If you email me, I'll send it to you. They're a great resource. For instance, one time I wanted one of these books, and I forgot what number. It was like quite a few years ago. I called. They FedExed it to me. Come on, maybe that would be for the last budget crunch or something. But yeah, you never know. And you know, and you can just count them, and you'll know how many. I think it is online. Yeah, and now, did everybody get my card? You know, you should keep that because I can be an incredible resource to you. I love talking about, is this a violation or that? You know, and there's no obligation. I'm free. And you have my email address. You send me an email. I'll send you an answer. Maybe I won't know the answer, and I'll look it up and figure it out and get back to you a day later. And I have an 800 number. Call me anytime. And so any of these things. Hey, what's that website for the DOJ's publication? And they have tons of publications that are really helpful, easy to use things like Small Business Guide to Making Their Business Successful. Another one I talked about in a presentation earlier this week was medical offices, doctors' offices, common violations, what they need to do to make their doctor's office successful. Whatever, they have all kinds of great resources. But absolutely.
I had to get a ultrasound for my kidneys and bladder and all that stuff in one office. And rarely got inside the room where they're doing everything. And the bench at the table you had to get on. I'm not kidding you. High off the ground. That thing lowered me over. I don't know how I'm going to get up there. They didn't have anybody that could lift me up. So I did that. He was just flying word and I'm up on it. Good law work.
Yeah, and is there anything more important than being able to have accessible healthcare facilities? It's, you know, I think they're getting better slowly, but sometimes they need to be pushed. You know, what's the first thing they do? You go to the you know, the nurse, before you even see the doctor, they're gonna weigh you. Well, a lot of these doctors don't have a way of weighing you, and somebody that uses a wheelchair or take a blood pressure, you can do that. But you know, things like that, and those are really essential tools because maybe it won't be a problem. Yeah, I'm not exactly sure why they weigh me, but they do it each time because, boy, you've lost a lot of weight, Mr. Potter. What's wrong? We do some other tests. Or here's an example of compliant parking, and see how they have. Let's say that the place you're going to is here to the left. Well, you can go up. If you parked all the way out here, you'd be able to travel in front of these cars without going. Where a lot of places you're not able to do that. You have to travel behind a car other than your own, you know, and then somebody's going to back over you in their Escalade. Here's an example of one that's not compliant. It may or may not be a problem for you. It spells out the dimensions that are supposed to be flat. Here, the ramp protrudes into that required dimension. For a lot of people, it's not going to matter. But for some people, it's going to matter a whole lot because their lift isn't going to be able to deploy on that crooked surface. And so it can be an absolute barrier to some people. I don't remember seeing one in the spot, but I've had several where they just put the cart return right in the access aisle because people just don't think about that access aisle actually serves a purpose. It's not just there for looks. And and another common thing that happens, it's kind of trendy these days to have you see the tables in the background, kind of You know, could we turn down the lights? I think it's see the tables in the back. They're the same height as the bars, and it's kind of it's a trend these days to have tables at the bar height with like bar stool height chairs, and they're required to have 20% of their tables lowered, you know, normal height. Yeah, in each area, they're required to have exactly, and so and it's I've had so many complaints about places that have nothing but high tables, and you know, you move that chair out of the way, and then the table's right here, and then these sorts of problems happen in all kinds of different sort of facilities. What kind of facilities have you run into where like a transaction counter or something like that is they only have the ones for designed for standing persons? Oh, really? I haven't heard either of those. A really common one I come across are banks. They'll have the lowered window because they had to have the lowered window to get their building permit. Yeah, those are a problem too. But they'll have it not. They won't have it staffed. They won't have it equipped. They won't have you know, cash drawer or my bank doesn't have the ATM but a lot of banks you have to swipe your ATM and put your PIN in to identify yourself. That's not, and they don't even have that at the lowered window. And now they changed the law. It's not as good as it was just a year ago, but they don't have to have it signed, the lowered window at the banks, and they don't have to have it staffed all the time. But if you ask to be helped at the lowered window, they have to, and if they don't, it's a violation of your rights. You know, these things can seem ticky-tack to some people, but then it's a big deal in some situations. You know, when I go to the bank, I like to talk to the person, and I never have my account number, and so I always have to give them my Social Security number for them to pull it up, and I don't want to say that from 5 feet away, you know, with other people in windows right near me, and or ask them what the balance is in a different account or something like that. And these are private things. You want to be able, and you want to see them count your money. It's, you know, and be treated. And a lot of my clients say they don't like sitting there looking up people's noses all the time, and so it's required by the law. And you know, these. To where? Oh. And they came around the counter and they gave them money, but again, yeah, they have it. That's right. They have to have a lowered transaction counter at every store. Yeah. Yeah, and they. And not only do they have to have it lowered, but they you know, I've had probably 3 cases in the last year and a half against DMV, and every one of these had a lowered area, but what was there? It was all their materials. They had all these baskets full of stuff, and it's very common where they I had a case against Kaiser where they go and put they have the lower window, lower area, but they just have all their junk on it. It's like where they put all their periodicals or displays. I don't. Some of my clients do, and I leave it up to my clients if they complain about it, and you know, and it's a case by case thing. You know, I think, and it's something that's kind of a sensitive thing, a politically hot topic these days. You know, should you complain? And I think sometimes you should. And you know, if they fix it, God bless them.
One time I went to the employee who worked there, you know, the politician or whatever. Oh, well, this is the way our district manager says we need to set it up. I'm like, okay, well, you can tell them that we weren't able to purchase anything. We weren't able to access the store. And I try to, you know, let her read, so you have to be an advocate. Let them know you would like to buy something. You can. But then you go back when nothing's changed.
Right.
So that's the time that you go.
That's right. That's right. Yeah, we all have our ways of advocating. Yeah, and, you know, like these banks, they've been sued many times, and they just, I don't know why they don't have somebody just stationed at the lowered window. Why do they're just less efficient if they're sitting down and they want them on their feet? I don't know, but for some reason they just do not like to staff those lowered windows. But they have to do it, and they shouldn't have to wait to be asked. But when they're asked, they got to do it. They can't. They'll often discriminate against you with a smile, like, "Oh, I can help you here," or something. Here's an example of, yes, unfortunately, signage isn't required. Here's a place where all the tables are like this one you can see over in the corner. That one's not accessible because, see how it has that pedestal there? So then you wouldn't be able to roll underneath that table. And so this is a good idea of them, to put a signage here. It probably says something like priority access is given to patrons with disabilities. So that if you come in here and it's empty, and you go to pick a table, you wouldn't pick this one first because you know if somebody comes in a wheelchair, you got to get up and out of that place. That was one thing in that AMC case that they're talking about. Gosh, they really should have a requirement for signage, because you know that guy that they wanted him to move, he got there and then my client came in there and he wouldn't move. They had signage, at least it would avoid perhaps avoid some conflict. Yeah, there's a lot of complaints about that. Unfortunately, that AMC won that issue with the Department of Justice. Yeah. A lot of them are better. Mm-hmm. Yeah, there's some. I don't know if you're. I'm in San Diego, but we handle cases throughout the state. I'm kitty corner from a giant theater that right across the freeway from me. And that place has an elevator to the back. Then you can to the back row. It's really nice. But the problem is, not every auditorium, it's one of those 16 plexes, but not every auditorium, it's then when you're just looking at the listings, you don't know which auditorium the movies are in. And so if you have a favorite auditorium, you know, there's like 6 of the 16 that have that upstairs one. Here's an example of, you know, at the hotel, they have the lowered window. And look at this Hertz counter. It looks tall for standing persons. The other problem is height reach requirement. That's a change that they made in the new code. Used to differentiate if it was a side approach or front approach. People always get it confused. Now it's just whatever. It's supposed to be 48 inches, within 48 inches high. And that's to the highest operable part. So if it's at a gas station and you have to push that button on the very top to decide whether it's credit or debit, you know, well, that has to be within the 48 inches. And it doesn't matter how high this key lock is to get into to stock the paper towel, because you're not stocking the paper towel. It's how high the paper towels are where you're grabbing it, or whatever it is that you need to use has to be within those height reach requirements. Point of sale devices, very common violation where they have them high. Even if it's like the right height, then it's at the wrong angle. You can't see the screen, and you know, a lot of people don't even want to give their spouse their PIN number, let alone some clerk at some random store. You know, I talked about gas pumps. And then things have to be operatable by one closed fist. Lever type, automatic, push button, but round twisty knobs, those aren't compliant. Everything's spelled out about restrooms. You know, look at this one. You have like you mentioned, being able to get underneath cabinet style sinks. Name of the game in retail is just to get as much merchandise out per square foot as possible, and then they'll cram it full where there's no way you're getting down that aisle in a wheelchair. And under the ADA, they have a general obligation to talk about really specific obligations. You know, here's the code, and if it's less than the code, it's a violation. But in addition to just the code, they have an obligation to alter their policies and procedures to provide for access. Hand controls at rental cars. That's not provided in the ADAG, but that's just under the general rules. They have, these rental car agencies have an obligation to alter their policies and procedures and provide hand controls on reasonable notice. Now, what's reasonable notice is going to be a case-by-case thing. You know, here, you know, at the San Francisco International Airport, Hertz, well, you're not going to need as much notice at that place as you would maybe in some very rural rental car agency. You might need to give them a little more notice for them to have a car equipped with hand controls. Okay, yeah, and that's way reasonable for San Francisco International. Now, I had a client. One thing I like about my practice is I'm always learning stuff. My clients are always teaching me stuff, something I never even thought of. Gentleman went to buy a new car last summer. And what are you going to do before you buy a brand new car? Absolutely. And how are you going to test? So he asked them if he could test drive it, but he needed hand controls. And he went to 2 different dealerships, and both of them refused to put hand controls on. Now, yes. Well, I mean, it's not decided. There's no cases out there, but rental car agencies have to do it, and so now, just analyzing it under the general rule. The general rule is that they modify their policies and procedures to provide for access to accommodate them. And you're entitled to be accommodated, but not necessarily the accommodation that you want, so long as it doesn't change the fundamental nature of their business. So now, if they had to drill holes in it or otherwise change that brand new character of the car, I don't think it'd be a good case, because you know that would change the fundamental nature of their business. I think if you could go in there and make that new car a used car just by test driving it. But I think he has a solid case because the rental car agencies, they all use these hand controls that you can put on, and any mechanic can put these things on really easy. And when you take them off, there's no way of telling that there was ever a hand control on it. They don't have to drill any holes. They clamp onto the pedals, and then they have Velcro that goes around the steering column. It's just no impact at all. And these guys, and they refuse to look into it. You know, and so what a business person should do is their answer shouldn't be just no. It's well, let me look into it. You know, maybe the answer is not yes, right? But but I'll look into it. Why do you think I can put hand controls on? I'm not going to make it used. I'm not going to damage the car just to let you test drive it. You have to have that. They have to have a dialogue and be open-minded. Think outside the box. And they didn't do that. And each one of these cases has, you know, it's bigger than just my client or me. Is this you know, if we're able to force them to change their policy, you know, they hang around other car dealer people, and their attorneys probably represent other car dealers. And the word gets out, there's just a ripple effect of compliance to where the next person that just rolls into the car dealer, they're not going to have to put up with that monkey business.
That's a vital point, that the other half of the equation of I don't know is let's find out.
Exactly. That's exactly right. And, you know, I had there was a guy that worked at the Independent Living Center down in San Diego, and he lived out in Ramona, the kind of small town outside of San Diego, and there was this liquor store he would go to, and they didn't have any accessible parking. He'd always ask. He didn't use a wheelchair, this gentleman, but he's an advocate, and he's always asking them to put in an accessible spot. One day he went there, and there's this beautiful, they had accessible spot there, and he said, "Thank you, that's great." And he said, "Oh yeah, my brother got sued You know, but if he wouldn't have had that dialogue, you would have never known why he had that accessible spot. But because of that other case, you know, there's just a ripple effect that you don't even know what caused that ripple effect. It's an unseen ripple effect of compliance, where it's just a really important part of the independent living movement. Just my little spot in the independent living movement of making it where people can live as independently as possible. I want to talk about the law in regards to existing facilities. So you have the ADAG, that's the code, spells out how things are supposed to be. Now let's say it's an existing facility that's never been altered since. Well, under the California law, that facility would be what they call grandfathered in. You know, they wouldn't have to. California's had disability access laws on the books since the 70s, and but you don't have to bring it up to the current code until you pull a permit to do something else. And just like the fire code or the plumbing code and electrical code, the ADA changed that. The revolutionary provision of the ADA is the readily achievable standard. And so it defines discrimination as a failure to remove barriers that are readily achievably removed. Now, barrier is defined by the ADAG. Anything less than the ADAG is a barrier. Readily achievable, it's not a specific formula like where you can just plug in the numbers and then you'll know the answer. But it just tells you to look at the financial wherewithal of the responsible party and compare it with the did I say financial wherewithal? Yeah, look at the financial wherewithal of the responsible party and compare that with the cost of bringing it up to code. So striping and signing accessible parking, that's always going to be readily achievable because it's just so inexpensive to do. Yes? Readily achievable? Oh, the financial wherewithal of the responsible party.
Is it true or is it not true that businesses are given a $5,000 a year tax rate in order to make modifications right along these lines?
Kind of. If you make changes to for the sole purpose of access, you can get up to a 50% tax credit up to $5,000 per year. And so if you made changes for you get a $5,000 tax credit. That's not a tax write-off, a tax credit. So if you lop that right off your tax liability. And so so let's say you had like a big project and it was going to be $20,000 to do all these renovations. Well, you start them in December, end them in January, then that's over 2 years. So you could get a $10,000 tax credit combined by doing that. But yeah. Yes. Oh. Uh-huh. See how I learn stuff every day? Never heard that. And I've been doing this for 16 years. Yeah, they should have some sort of cane or Right. Right. Right, and not until you're stuck in that situation.
What are you talking about?
Oh yeah, he was saying that he rented a car from Enterprise, had the hand controls and everything, but the parking brake was foot controlled. Right, and so I mean, what would be the way around that? Like if you had a cane. Sure. But if that was the car, like very few of them have them here anymore. It seems. They're yeah. And so in that situation, what would you do? I don't know, but you have to think outside the box to think of it. You know, like a cane would do it, or just have something. Yeah, maybe. Right. Oh yeah. Oh, in the future, they heard that one, right?
Yeah,
absolutely. Okay. Yeah. Mm-hmm.
Limit or the husband was working with someone for a laundry model business, but if he did put too much money into remodeling, that sounded like that would make it so he had to make it acceptable. Does that make sense?
It does make sense, and I'm going to repeat the question for the people online. The question is that she knew somebody that was remodeling their business, and they didn't want to spend more than a certain threshold because if they went over that threshold, they would have to spend money on making it accessible. And under the California law, there is some sort of threshold, but I don't know what it is. Under the federal law, there is no threshold. It's 20%. If you have to put 20% of your renovation costs towards access unless it's fully accessible. And so, but unfortunately, California state or the local municipalities here in California don't have the right. They might under the new laws, but they didn't have the right to even enforce federal law. And so he may have been right because they were only enforcing California law, but then you still have the readily achievable issue though too. Is in the local municipalities won't enforce readily achievable. They just don't go around and enforce these laws. It's left up to individuals. You know, the Department of Justice, the United States Department of Justice, they'll pick cases here and there. Like they look for high impact cases. But they're not gonna make that gas station down the street from you or the Lucky supermarket or what have you. They're not gonna deal with those things for you. They're looking for bigger things. And so it's left up to individuals to force these issues and make it accessible. Let's see what else on the readily achievable. You got it. I don't think I fully analyzed the readily achievable issue for you. Like parking, that's always going to be readily achievable. The Department of Justice has a list of per se items that are per se readily achievable. You know, ramping small curbs, stuff like that, striping and signing parking. You know, if it's like a mobile gas station, there's very little that would not be readily achievable to them. But an example of things that might not be readily achievable would be maybe there's like a mom and pop taco shop and they have a really tiny bathroom. And once you have to knock out walls to make a bathroom accessible, well, once you knock out walls, that's really expensive. It's probably hard to do it for less than $20,000. And where are you going to expand into? You know, some tiny little taco shop, you know, you knock out the walls and then you're like taking up the whole kitchen. So those are examples of things that might not be readily achievable. Another one are like where there's a step up into the business and it's right on the public sidewalk. And so they don't even have room on their property to put a ramp. You can't require them to put a ramp on somebody else's property. Well, in those instances, maybe it's not readily achievable, but they have an obligation then to do the next best alternative accommodation that is readily achievable. And you have to think outside the box to think of what would be the next best alternative accommodation. You know, we talked about this a little bit earlier, Marv, where you know, maybe it's putting a sign that says portable ramp available and a buzzer, so you can get people's attention. They can bring a portable ramp out. Or you know, if it's a deli, maybe they provide wait service. You know, they have some tables outside, and everyone else has to go wait in line and order, but you get their attention. They bring you a menu, take your order, make your name. My office was inaccessible. Well, I'd have if I didn't have an elevator in my building, which I do, but then I'd have an obligation to come meet you at an accessible location. I couldn't just say, you know, sorry, you know, tough luck. Yes. Mm-hmm.
I can't understand you.
Yeah, and how long ago was that building built? Oh, it's done. Yeah. So the question is, repeat it again for the internet users. The question is regarding his cousin that got a condo, a brand new building, and doesn't have an elevator. Now, the ADA first doesn't deal with housing. It deals with businesses that are open to the public, and then also governmental entities. They are covered under Title II. And there's housing laws specific to your situation. Now, the rental office, it is a business open to the public, and so it's covered by the ADA. But the housing itself isn't. It's covered under the Fair Housing Amendments Act, federally, and state. It's California Fair Housing and Employment Act. And there's a lot of tricky stuff in the housing. And whenever you look at any of these other civil rights laws, boy, it makes you really appreciate the ADA. The ADA, like any law, has some flaws, but boy, it's a powerful law. These housing laws, they have a lot of tricky stuff in them. One is that the statute of limitations runs on a brand new building like that, and so even if they slip that in under code, I forgot what the statute of limitations is, but it goes, and then it's gone. It doesn't matter, this thing was built after the code, and then the statute of limitations just expires, even though I just want to move in there now. Why is my statute of limitations gone? It's terrible. And then elevators can be, if this was in a business, getting vertical access can be very difficult under the readily achievable standard. As you imagine, it's very expensive, and so I'm trying to think of the only cases I've been able to force the issue on an elevator is when they had an elevator. Had quite a few where places have decided to just not have an elevator. But they can't do that, and they just like board it up or just put an out of order sign on it forever. And yeah, they have to maintain their accessible features. But I haven't been able to force one to put in an elevator that didn't have one to start with. What? Cooling? Oh, pulley system. Oh. Yeah, that's a good. You get one of those giant forklifts. Now, new construction though in the ADA is just no excuses. For instance, when that California Speedway case, that was new construction. That thing was built. The California Speedway, it's down in Fontana. Yeah, it's post ADA, and so that made the case nice because it was just there was no excuses. But then they had their argument was, and they actually had a good argument. We had a really good judge in the district court level, a guy I really respect, and he ruled against us in the lower level. But the Ninth Circuit reversed on whether the code required clear line of sight over standing spectators, because you had the accessible seats had a good line of sight so long as no one stood up. But every time something exciting happened, of course, everyone stood up. And anyway, yeah. So for new construction, no excuses. They would have had to tear the whole thing down if that's what it took. But really, all you have to do is remove a row of seats. Yeah.
So I began the know the law itself.
Mm-hmm.
But so who's the advocate
the laws on the books. Most people don't even know three-quarters of it, right? Some are ridiculous, some are outdated. Where's the actual part from the law, or the ICC, that is actually operating guide for all the states to write their codes to build? So it's one thing to say a law and you can write it whatever the heck you want. The other thing to put it into a usable format that builders and others can use. So who is that entity that goes to the ICC conference? The reason I bring that up, I work for the Carter Code. We send people back to ICC every 4 years, whether it's trying to advocate for sprinklers or elimination of wood truss, roof materials that fail quicker in a fire. And we do that because we know we have to advocate for safety provisions for the fire code. And we do that at a national level. But I understand where you're coming from. I'm just wondering who's that catalyst and that connection between the law and the actual operating code that makes some of the builders, so if I want to build an apartment complex or whatever they have to do, it's actually, it says it in the code, it's not a law. Most people don't look at law, they look at code.
The building code.
The builder, I look at the building code.
Yeah, well, the ADA in the ADAG is like a federal building code, and a lot of building departments, it's incumbent upon them to point it out when they do plan check and say, no, this doesn't meet the federal building code. And in the architect that's drafting the documents, if they're able to get it past the building code, but it doesn't meet the federal guidelines, they're taking a big risk because they could get sued for malpractice if it turns out that the California Speedway that they designed doesn't meet the federal guidelines. But now, who is making the California building code try to comply with the federal guidelines? I don't know. But
California, all the states are basically going on to international code. And drawing the changes out of that and then putting in the divisions of their own code. California does. But my point is, so where does the law stop and somebody actually takes and puts in the ICC code provisions for the ADA? Because I know that our building official has 4 different jurisdictions that we operate in. That at least in the one that I deal with quite a bit, they do that. I just don't know how it gets from the other talking about into the local code. It's not referencing a separate ADA set of rules.
Right. Yeah, I don't know, and I might be misunderstanding the question a little bit, but if I understand it correctly, I don't know the answer. But the ADAG is spelled out really clearly. You know, the Americans with Disabilities Act, it's like you say, it's just a law, but then the ADAG are the regulations that are promulgated under that law by the Department of Justice, and it's really detailed. There's not much ambiguity. There's very few instances of ambiguity. Most, if you want to know how to stripe and sign your parking lot, it's spelled out absolutely clear. The only ambiguous part I can think of in there is on the distribution of where they are, like in a big shopping center, how many in front of this store and how many in front of that store. Other than that, it's spelled out exactly, just like a building code, very similar to the California building code is. And how your restrooms to be configured, everything in regards to disability access, it's spelled out just like a building code. I missed.
Last question, I have a hard time. What I have a hard time believing is the federal code for 3 years. All kinds of things happen all the time.
Oh,
Every day we walk out of our building, they can change things back and walk out. They can do all kinds of things.
Oh, yeah.
They do the things that that's what we can do. I guess, on the part where people bring up the issue, not having no other how do we use it? I don't understand what some of the things.
Yeah, it's not very open either.
Yeah.
I
privately or some sort of scheme.
How big is the complex?
Probably what, eight condos per floor, and then you got another building across the way, you got another building in the third. So I mean, it's not a big. I mean,
Yeah, that's surprising. It is.
I even before my accident was asking,
And how many floors are there? Yeah. Oh yeah.
Well, people think it's down. That's the thing. It's like the place on the corner of Hamilton and Winchester and High-Rise. Yeah. There's no elevator in there, so anytime they lost power or whatever in there, they have to take them down by hand.
That's like.
Yeah, that's because it was.
Yeah.
Well, I was heard I'm talking saying this is the reason why I think it should be bottom level accessible to the ADA. That's what I was told.
Yeah, and that's thoughtful for of them to. How would you get upstairs?
Yeah, how would I get upstairs? How would I get up, you know, that's my family. Now I can get up there, I'm open, I can get up there. It's just down, it's your problem. It is my problem, it is my problem.
Can I ask you a different question?
Yes.
So one of the things, I'm just kind of curious person.
Mm-hmm.
I got a lot of respect for what you do. I'm new to this game, so I don't claim to know very much about any of this stuff other than from my profession. But, you know, so the one thing I know for all of us here, we're kind of in, we're the people that have these issues, like we're wheelchairs, we're the ones that are going to have to address these issues. So for you, you got into either law school or what motivated you to become, have a specialty in this area? You know what I mean? What's below the surface in terms of your motivation for doing what you do and the way that you do it?
I just fell into this area of law. I was doing general civil litigation. I've been a lawyer since '93. In '96, I don't know if you remember, that was there was a guy was networking my computers in my office. Networking computers was the new thing, and I graduated from law school before the internet. And so this guy, he was paraplegic, used a manual wheelchair, he had this thick Bulgarian accent. One day he came to my office and he was just fighting mad about this gas station next to my office. He wanted to go get a Gatorade, and this Arco had a step like this big to get into it. And so he went across the street to a Shell station and it had a step this big to get into it. And he explained to me that the ADA requires them to put in ramps, that they can't just have these curbs into their place since the ADA was passed. And I researched and I couldn't figure out why he was wrong. And so I sued both of them for him, and we were able to force them to put ramp both their stores, and the case worked out. The cases worked out. And now he was in Los Angeles, and I was down in San Diego. So he's networking computers in a pretty big range of areas, and he ended up suing like over 100 gas stations because that was his. At the time, none of the existing gas stations were being fixed. They weren't. There wasn't just like Arco and Shell weren't just fixing all their gas stations because the ADA passed. They weren't fixing any of them. The only ones that were accessible were ones that were built subsequent to the laws being passed. And so at the time, he had about a 40% chance of not being able to get gas at any gas station he stopped at. And so it just really fit with me, making places accessible just made sense, because you make them accessible, people like him can do their profession. If he can't buy gas, he can't do his profession. And that just clicks with me. And so I got involved in the Californians for Disability Rights, Chapter 1, and just got involved in the community. And then I was on the board of directors of an independent living center down in Downey, California. And I'm just wired to not like bullies too. My favorite cases are ones that are like against mobile home parks, because and I don't know why it is, but it just seems like the managers and owners of mobile home parks are like push people around a lot. Yeah. So I don't even have to, it just always it works that way. I had a case last, I think I settled it like 6 months ago, where a guy, these are just my favorite type of cases, where here's this guy, he's taking care of his grandbaby that has special needs, and they're trying to kick him out because it's a 55 and over park, and he's got a 6-year-old grandbaby with him and his wife, and this was back when they were trying to kick him out right in the depths of the recession, and this guy was panicked. He's gonna he has a for sale sign on his mobile home park, his coach, and he doesn't make much money. What's he going to do to provide for his family? There's no way he's going to be able to afford. He's going to be selling this thing at a fire sale, and then he's going to. There's no way he's going to be able to afford something else equivalent to provide for his family. And these people, other than the school bus picking her up, they would never even know she's there. She doesn't say a peep. She's not out there bouncing balls against somebody's wall or something like that. It's just, can you imagine somebody wanting, you hear all the time in the press about people, where's the parents, who's taking care of these kids? And here's this guy, he's stepping up and doing the right thing, taking care of this kid. They're trying to kick him out. And they base it on some law that, well, we're 55 and over park, we'll lose our status. But that's not true, because you can have 20% of your residents under 55 and still qualify for that federal program. And she doesn't even count towards that 20% because he's over 55. And so that was just complete nonsense. They're just being bullies. Who knows? Maybe they're trying to maybe they were going to try to take his coach or something. It's just, so I'm just wired to deal with situations like that. It just drives me nuts that people bully people around like that. And, Yeah. I have another one against a mobile home park where I sued this mobile home park because they wouldn't put a gap in the speed bumps they have all over the place. The speed bumps go curb to curb, no sidewalks, so she can't get around in the place because she can't get over these speed bumps. Come on, just grind some holes in this stupid thing. So we had to sue them. They litigated this case for a long time. These real jerks. This guy comes in, flies in his helicopter to the vacant lot next to his mobile home park and stuff. Loves to just push people around. And so until they finally figured it out, like 8 months into the case, that there's no way they're going to win this case. They settle it, and then they start picking on her again. She has a ramp, and all that the wood on that ramp is too close to you can't have wood. You can't have anything combustible within this distance. And you know what? I don't think there's one mobile home park in that entire mobile home park that doesn't have some eave made out of wood that goes to the lot line of their little lot. They're just full of it. They're just pushing her around. They're picking another fight with her. Yeah. Are you allowed to ramp it? Yes. Yes, you are now, because to ramp up to your. Yeah, you have to be able to do it on your lot, and now let's say that they have some policy of no ramps, right? Well, exactly. They're going to have to. Yeah, so you could. Right. But let's say that they just did, because you're asking, are they allowed to? Well, let's say that our rules say no ramps, right? Well, that would be a permissible rule for everybody that's not disabled, but somebody that needs that, you would need to modify your policies and procedures to accommodate this person. Absolutely. And that will come under the housing laws, but the housing laws have an obligation to the housing laws to alter their policies and procedures to provide for access.
They're far away from the house. Real far
And I
away.
mean, even our cutting spot is so, you couldn't even get in and out.
Yeah, if I park the van in front of the house, I get it. Say, that's a fire lane.
Now, I'm gonna have to go to catch a plane. But now, here's the thing: you'll have all kinds of stuff that come up. Man, this thing really bugs me, or I wonder about this, or whatever. You have my email, you have my phone number, and I'm just a great resource for you. And you know, some of you are gonna, you know, you more inclined to like not want to sue somebody, or you want to advocate for yourself first. And you know what? That's great. You know, if they fix it when you ask them to, God bless them, and you know, move on. You know, you don't have enough time in your day to fight with everybody, right? But you have me as a free resource anytime you want. And
I had a lot of trouble trying to find work, even though I've been doing things like 15 years, doing things like 9 years. But what are some good organizations to help with interviewing and ways around disability, or how to deal with disability, you know, looking for work? I know Project Hire, but I'm not having a lot of luck right now with that. Is there any other organizations?
I don't know. But I'd be willing to look for you. Did you check with your independent living center? Uh-huh.
Just not, so far, not been very helpful.
Mm-hmm.
Wondering maybe there's another, and I'll do that more, but
Okay.
kind of frustrating.
Yeah.
Mark, I've only learned tonight a couple of things that weren't legal that I took it off with. And I'm sure it's coming from both companies. Tonight, we got our hands on that, so I come home at the end of the day and go, you know, I'm not sure what I just saw today was right.
Absolutely. Yeah, and the ADAG, it's online. So email me. I'll give you the link for where the ADAG is, and then there's also a good book out there. It's called CalDAG, and what's nice about it is, and I think there's one other book like it, where you can look it up in the index, and it'll have the California and federal law laid out in a little more easy to read format, like it with explanation. Yeah.
You can't do that. I know it's illegal, you know, and you don't want to assume that.
Sure, and you can look it up, and then, or you're also welcome to just email me, and you know, like ask Jeeves, I'll give you the answer. Just maybe not as fast as we. Okay, absolutely.
I know you're going to run. One of our viewers had a question.
Sure.
You just quickly speak here. Her name is Jacqueline. She was just wondering if you could speak to where the ADA will be in 5 to 10 years, or if you have any thoughts on how it's progressing.
Yeah. You know, you know, here in California, we've had some law changes because, you know, we're really lucky we're here in California, because the ADA just is not as powerful outside of California, because you really need the California law in conjunction with the federal law. I don't have time to explain all those things, but they've had some law changes here that were to take care of some perceived abuses of people that are filing too many cases and such. And you know what? These laws that they changed, a lot of the advocates were really up in arms about it. But I take a different perspective of those changes, because I thought that a lot of the changes weren't that bad. They made it to where people can fix their facilities right away, and then lower the damages that they're possibly liable for. And that if they have their facilities inspected by a CAST inspector, then they're entitled to put a stay on the litigation until there's a settlement conference, so the attorney's fees don't get out of control. And I think these are really good changes. And the other thing that was really heartening is that they never was it close to them getting the legislature getting rid of the ability of individuals to enforce their rights under the ADA. And so I really feel like the disability rights laws are getting stronger. And you know, shoot, I thought I was going to be out of a job more than 10 years ago. I just thought everything would be accessible. You know, in 1996 when I was doing this, how long would it be till everyone got it fixed? Now I'm wondering if it ever will be. You know, because there's still what? I think there is. And but anyway, I feel like the laws are getting stronger. And you know, I think that. Yeah, you know, there's some instances where it is, you know, like service animals, it's actually a violation of the penal code, but no, really, there's so many things that it shouldn't have to be a law, but you.
Thanks for answering my question, Marv.
Uh-huh.
Your house or whatever, and yet it's one of the cheapest forms of
Hey, thank you guys. Thank you.
The asset that I for one will be utilizing. It's very simple. It's, you know, get you and have your tummy.
Oh, hey, one important change in the law, this is, talk about criminal penalties. This is one really important thing. There was one perceived problem out there. I didn't know about it until this law came out, but that apparently there were people that were demanding money and not filing lawsuits, and so they made it actually criminal. Yeah, and so they made it illegal for you to, so it's kind of sketchy to go and self-advocating, because you have that conversation. Well, if they say you demanded money, then they're accused. That's a crime. And so it's unfortunate, because that's one of the criticisms. People would say, why didn't you complain first? But there is a risk in complaining, because if you ask for, let's say at your hotel, you're complaining, and you say, why don't you comp me, stuff like that. Well, you may be committing a misdemeanor. Just the fine print at the bottom of the presentation. Absolutely. This is your table. Okay. Hey, so I'm going to scurry out of here. I got to catch a plane. Thank you very much.